Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question for Attorney Murphy today is, how does the family court determine what is in the best interest of the children?
So when a court is given the assignment to determine what is an appropriate parenting plan for children and what is a good custody arrangement, there are several different ways that a court can gather that information and then synthesize it in some way that would help the court best decide how to act in those children's best interests. And some of that will be from evidence that's presented by the parties. Some of it will be by the testimony of the parents themselves. Some will be perhaps testimony of caregivers or relatives or collateral sources, whether those are healthcare providers, medical records. But really the most common way that a court can gather information from children, because this is not a circumstance where children are paraded into court and put on a witness stand. It's not something that any court ever wants to do. So the most common ways are through custody studies. And custody studies here in Connecticut can be done in a number of ways. So there's the Family Relations Office, which is part of the Court Support Services Division through the judicial branch of the state of Connecticut. And it's a free service. It's an office in every single courthouse where the case would be assigned a family relations counselor. And the counselor can conduct what's either called an issue-focused evaluation, which is exactly what it sounds like. It's focused on one particular issue of custody or some particular dispute where the parties have been able to reach an agreement on some things, but maybe there's something else that's holding them up. Or there's a more comprehensive evaluation where the parties are asking for the family relations counselor to really opine as to what the ultimate parenting plan should be and what's in the best interest of the children. That's a more in-depth approach and a more in-depth process. And in both of those cases, the family relations counselor speaks with collateral sources. Home visits may be conducted as part of the work, including seeing the children, talking with the children, seeing the children interact with each parent. And a family relations counselor can and likely will ultimately testify at trial if the case does not settle. So the input from that individual, while it's not binding, that input will be considered by the court and given some value in the court making its determination. Another option is a private custody evaluation. And that is also just what it sounds like. It's a custody evaluation that's similar to the family relations one, but it's done by someone outside the courthouse. It's not free. It can be more in-depth than an evaluation that's conducted by a family relations counselor. It's usually conducted by a psychiatrist or a psychologist or a clinical forensic psychologist of some kind. Often it will involve some sort of psychological testing component. And there are home visits, which can be a part of that as well. Also discussion with the children and observations of the children with each parent. In that process as well, a private custody evaluator will review source material that may be provided by either side, either parent, sometimes through the lawyers or through the parents, as to any claims or defenses they might have. And that could sometimes be related to the cause for the breakdown of the marriage. It could be related to parenting issues that came up during the marriage. Those materials might sometimes relate to health of the children, the well-being of the children, psychological well-being of either of the parties. A private custody evaluator will ultimately put together a report, and that report will be disseminated to the parties and the lawyers. And that person may ultimately be deposed, have a deposition taken under oath, and may also testify at trial if, in fact, the parties cannot reach an agreement as to their dispute before a trial is had. Another way that the court can and often does learn about information that's relevant to the best interests of the children is through the services of a guardian ad litem. And a guardian ad litem is an attorney specifically trained to advocate for the children's best interests, regardless of what the children may actually want or say that they want, or regardless of what the parents might say their children want. It's the guardian ad litem's role to speak for his or her wards and to essentially advocate for what's in their best interest under the totality of the circumstances. So again, a guardian ad litem will do some similar things will meet with the children and hear from both parents. We'll observe both parents with the children at different times. We'll gather information throughout the entirety of the case about different conflicts that arose both before the filing for the divorce and even during the litigation itself. And that person will also connect with family relations if they're involved in the case, or with the custody evaluator if there is one. And ultimately, a guardian ad litem also will testify at trial as to the best interest of the children.
So how do I know what is the best situation for my particular case?
So there are a number of factors that go into whether or not your case would require a GAL, which is a guardian ad litem, or a private custody evaluation. Cost is obviously a factor. Some of these steps are not inexpensive, certainly not a private custody evaluation. And sometimes more than one of these things happen at the same time. A guardian can be involved with a private custody evaluation or with a family relations study of some kind. And it may also depend on the particular educational or psychological needs of the children involved in this particular case. Any parent who is involved in a divorce or even a post-judgment matter where there's custody issues that cannot be resolved should certainly speak with a lawyer about what the case may call for in that particular instance, and how the best way would be to have the children's voices heard and their best interests squarely addressed by a court, or hopefully by way of a settlement.